only in Ukraine's written statement and in the submissions of the interveners that the interpretation of this provision came to the front. In the memorial, Ukraine was mainly concerned with Articles 1 and 4 of the Convention. Second, the emphasis put on Article 9 by Ukraine and the interveners suggests that they too recognize that no other provision of the Convention could be interpreted as incorporating other rules of international law and expanding the Court's jurisdiction ratio materia. In other words, it is now Article 9, what is being presented, at least by some, as the gateway for the Court to go beyond the substantive provisions of the Convention. Third, Ukrainian interveners seem to rely on Article 9 in different ways. Ukraine itself seems to argue that, under this provision, the Court has jurisdiction to hear claims regarding to an abuse of the Convention, to justify unilateral use of force, or the recognition of states within the territory of another state. As we have shown, Ukraine's reliance on an abuse of rights doctrine raises a separate problem for Ukraine, the inexistence of a right under the Convention that could have been abused in the circumstances of this case. I will get back to this shortly. But if Ukraine's suggestion is that Article 9 somehow grants jurisdiction, more generally, to rule on breaches of obligations not set forth in the Convention itself, the argument must be rejected. As we noted last week, the interpretation of Article 9 advanced by Ukraine contains many flaws. I will now explain briefly why this is so. Maître Chikaya will go into some more details later this afternoon in response to the submissions of the interveners. The first fundamental problem in Ukraine's position is that it simply ignores the fact that the Court has already clarified the scope of Article 9. We addressed this in detail, but since you were told for several hours, including by Ukraine, that Article 9 is an exceptionally broad compromissory clause, I hope the Court will indulge me for restating, only once and briefly because there is no need for more, what the correct position is. The Court has already clearly, unequivocally determined that Article 9 does not empower the Court to rule on alleged breaches of other obligations under international law not amounting to genocide. That Article 9 confines the Court to disputes regarding genocide. The jurisdiction under Article 9 is confined to obligations arising under the Convention itself. That the Court can only rule within the limits imposed by the Convention. Similarly, in the legality of use of force cases, as we noted last week, the Court did not see the allegations of genocide as bringing within the jurisdiction of the Court, under Article 9, questions relating to the use of force. Arguments were advanced by the parties on this question. Yet the Court did not consider, even proprio motu, that Article 9 could confer upon the jurisdiction over alleged violations of the UN Charter. It is surprising, Madam President, members of the Court, that last week you did not hear a single word, not one, concerning your previous decisions on this matter. Ukraine and interveners had more than ample opportunity to address them. They chose silence. This silence is revealing. It reveals in the clearest way that this case is not about an alleged breach of the Genocide Convention. If it were, they would have no problem in acknowledging your interpretation of Article 9. They cannot do this. Be that as it may, your clear and consistent interpretation of Article 9 is the correct one. To argue otherwise, Ukraine puts emphasis, for example, on the word fulfillment. But fulfillment, as Ukraine notes, simply means compliance with or performance of the rules enshrined in the Convention, determining whether a state has complied with its obligations, and if not, what the legal consequences of a breach are. That is what the Court does in all cases brought under a compromissory clause, even if it does not use the word fulfillment. This understanding is confirmed by the 2007 judgment in the Bosnian genocide case, where the Court stated that the addition of the word fulfillment was not significant, and that Article 9 by itself did not impose obligations on the contracting parties. There was no disagreement among the judges on this conclusion. Judge Skotnikov, for instance, stated that the addition of this word, fulfillment, in Article 9 is not particularly significant. Similarly, Judge Tamko stated that fulfillment does not add anything to the substantive obligations of the parties to the Convention and does not expand the Court's jurisdiction ratione materia. Ukraine also refers to the phrase including disputes relating to the responsibility of a state for genocide. This is the phrase that the Court found unusual in the Bosnian genocide case, not the word fulfillment. Indeed, it was by interpreting this phrase, together with the substantive provisions of the Convention and the object and purpose, as well as the drafting history, that the Court came to the conclusion that Article 1 obliged states not to commit genocide themselves. Nothing more can be deduced from this phrase. Ukraine seems to suggest that because the word including is used, other types of disputes are not excluded from the scope of the compromissory clause. But, as Article 9 makes clear, the dispute must in all cases relate to the interpretation, application, or fulfillment of the Convention. Nothing in Article 9 could justify expanding the Court's jurisdiction to alleged breaches of other rules of international law. The Court has already said so expressly. Finally, a short word on writings. Ukraine and all the interveners refer to a book chapter written by one professor, but they cite a single sentence taken out of context. What they fail to mention is that in the same chapter, the author also explains that, I quote, "The compromissory clause does not expand the jurisdiction of the Court to areas not covered in other provisions of the Convention." And that in Bosnian genocide, I quote again, "The Court stressed the intrinsically limited jurisdiction under the compromissory clause." It appears, therefore, that the author cited by Ukraine and interveners correctly laid down the proper scope of Article 9 of the Convention, having due regard to your previous decisions. In the same vein, another well-known author has noted that, and I quote, "Jurisdiction under Article 9 covers disputes under the Convention only, but not disputes relating to other rules of international law, even where they are intertwined with allegations of genocide." To conclude on this point, Madam President, members of the Court, there is nothing exceptionally broad about Article 9 of the Convention. It has the same scope as other compromissory clauses under the auspices of the United Nations. It limits the Court to alleged breaches of the Convention itself. Article 9 most certainly does not impose additional obligations on the contracting parties. The compromissory clause cannot serve to incorporate other external rules into the Convention. Madam President, let me now turn to Ukraine's attempt to incorporate rules into the Convention through an alleged obligation under Articles 1 and 4 to act within the limits of international law. I can be brief because Ukraine did not have much to say last Tuesday. It was only suggested that Ukraine did not seek an incorporation in this case, that the Bosnian genocide case and the order on provisional measures in this case sufficed to determine this issue, and that the object and purpose of the Convention could lead to an incorporation. Madam President, the meaning of incorporation is well known, and the Court has never admitted such an argument to date. Incorporation means importing into a treaty rights or obligations that do not arise under the treaty itself. States sometimes seek to incorporate external rules as self-standing, independent rules within a treaty, as was the case in oil platforms. Sometimes states argue that external rules to a treaty are reflected in certain provisions of the treaty. That was the case in certain Iranian assets. And at times, states maintain that a treaty includes rules arising from other sources of international law, so as to address the manner in which a state has to perform its obligations under the treaty in question, whether they executed their obligations under the treaty without breaching other rules of international law. This was the case in immunities and criminal proceedings. It is also, quite evidently, the manner of incorporation that Ukraine seeks to rely on in this case. Last week, we pointed out that accepting Ukraine's position would open the door for all kinds of disputes unrelated to the Convention be brought to the Court, invoking Article 9 alone. A few examples may help illustrate this point. A state could, for example, institute proceedings against another state for an alleged violation of the customary rules on the immunity of state officials from foreign criminal jurisdiction for prosecuting an official for genocide pursuant to Article 4 of the Convention. A state may also come to the court to challenge the legality of unilateral measures or sanctions adopted by another state on the basis of allegations of genocide. Such measures, which are not uncommon in cases of an alleged genocide, may be claimed to be in violation of a myriad of rules of international law with no connection to the Convention itself, depending on the circumstances. And of course, the claims I am speaking of may not only concern the legality of measures that could be adopted by states in the future. States may also seek to challenge the legality of past measures. Nothing in principle would prevent this if the parties have accepted the court's jurisdiction under Article 9 of the Convention. It is precisely because of the endless scope of disputes that could be brought under a compromissory clause, unrelated to the substantive provisions of the treaty in question, that the court has consistently rejected attempts of incorporation. As the court stated in Djibouti versus France, the consent allowing for the court to assume jurisdiction must be certain. Whatever the basis of jurisdiction, the attitude of the respondent state must be capable of being regarded as an unequivocal indication of the desire of that state to accept the court's jurisdiction in a voluntary and indisputable manner. The court made a similar point in the Croatia genocide case, where it was stated that a discernible intention is necessary to expand the court's jurisdiction beyond interpretation, application, or fulfillment of the Convention itself. In that case, the court concluded that Article 9 did not confer jurisdiction on the court even regarding claims of breaches of customary obligations regarding genocide, that is, external rules having the same subject matter as the Convention. It follows, Madam President, that Ukraine's attempt to incorporate other rules of international law, including the UN Charter, cannot prevail. The text of the Convention does not come close to showing an intention, a discernible and certain intention, by states to incorporate those other rules and to submit their disputes to the court. The drafting history is of no assistance either, nor is the object and purpose of the Convention, important as it is, because it cannot suffice in itself to expand the court's jurisdiction beyond what states have consented to. As we showed last week, the Bosnia genocide case cannot be relied upon either. When the court said that every state, not the contracting parties to the Genocide Convention specifically, may only act within the limits of international law, that was a general statement of law, not a conflation of obligations arising under different sources, or an expansion of jurisdiction under Article 9. Again, in the same judgment, the court determined that jurisdiction only covers alleged breaches of the Convention itself. In immunities and criminal proceedings, the court was careful in delineating the subject matter and scope of the specific treaty in relation to other rules of international law, even if those other rules may have been breached when executing the specific treaty, and even in the face of express language that could have led to an incorporation. The same approach is clearly also applicable in the present case. Again, in the Bosnian genocide case, the court was simply clarifying in which circumstances a state may not be found responsible for failing to prevent genocide. The court avoided putting states in the situation where they would face conflicting obligations. Ukraine also relies almost exclusively at this point on your order on provisional measures. But the order in no way prejudges the question of the jurisdiction of the court or any question relating to the merits. It is now that the court is called upon to determine the question of jurisdiction, having before it the full arguments of both parties. Ukraine also refers to the court's finding in Bosnian genocide that states have an obligation not to commit genocide themselves, even if this is not stated expressis verbis in the Convention. But as I noted some moments ago, the court arrived at this conclusion after a careful interpretation of the actual text of the Convention, in particular its Article 1, the object and purpose, and the drafting history. This step was taken, I would add, with respect to an obligation that goes to the heart of the Convention. In the present case, the suggestion that the Convention obliges states, by implication, to comply with all their obligations under international law has no basis. Has no basis in the text or the drafting history of the Convention. And accepting Ukraine's position would lead to similar implicit obligations we read into all treaties, with ensuing consequences for the system of compromissory clauses. To be clear, Russia's position is not that states do not have to comply with their obligations under international law when executing or giving effect to the Convention or to any other treaty. The position is simply that this is not a treaty obligation under the Convention itself. The Court's jurisdiction retiene materia under Article 9 cannot be expanded on this basis. Madam President, members of the Court, I now turn to Ukraine's reliance on an abuse of rights doctrine. As we explained last week, for this argument to have merit, Ukraine must first establish the existence of a specific right under the Convention that may be the object of abuse. Ukraine does not contest that a right that does not exist cannot be abused. It does not contest that the alleged abuse of a right that does not exist under the Convention cannot be the subject of proceedings under Article 9. We also showed that Ukraine's position regarding the precise right that was allegedly abused in this case is obscure. Ukraine does not say anything, for example, about the right to recognize states under the Convention, even though the recognition of the DPR and LPR also forms part of its submissions. And when it comes to the unilateral use of force, Ukraine suggests that the Convention confers such a right, only to then deny that they exist under the Convention. The slide on your screen shows Ukraine's clear hesitance to assert the existence of a right to use force. Madam President, members of the Court, Ukraine's hesitance is understandable because it cannot be seriously suggested that the Convention confers a right to unilaterally use force, a right of humanitarian intervention. The use of force is regulated by the UN Charter and customary international law. The inexistence of a right of humanitarian intervention was confirmed by states in the 2005 World Summit Outcome document. Reading a right to unilaterally use force into the Convention would entail creating a novel exception to Article 2, Paragraph 4 of the Charter. Such an interpretation of the Convention would have no basis whatsoever in the text or the drafting history of the treaty. Issues relating to the use of force, again, do not fall within the scope of the Convention. Another problem with Ukraine's position is the way it argues that Articles 1 and 4 of the Convention contain rights and obligations at the same time. By doing so, Ukraine seems to agree that an abuse of rights doctrine may only apply to rights, not to obligations. It could, of course, not be otherwise. But Ukraine is wrong to suggest that the prevention and punishment of genocide are rights of states. The difference between obligations and rights is straightforward. An obligation is something that a state is obliged, mandated to do. If the obligation is triggered, the state must comply with it. In case of breach, the law of state responsibility will apply to determine the legal consequences. Rights, for their part, are something states are free to exercise. States are not required to exercise a right. The Court jurisprudence makes clear that Articles 1 and 4 impose obligations. As the Court noted in Bosnian genocide, I quote, "The ordinary meaning of the word undertake is to give a formal promise, to bind or engage oneself, to give a pledge or a promise, to agree, to accept an obligation. It is a word regularly used in treaties setting out obligations." End of quote. These obligations are of an erga omnes partes character. They are owed to all the other contracting parties of the Convention. The only correlative right for a state arising under Articles 1 and 4 is to invoke compliance with those obligations by other states when they are required to do so. As the Court noted in the Gambia versus Myanmar case, this includes the possibility to invoke the responsibility of the state which has failed to prevent genocide, which, in the case of the Convention, is contained in Article 9. So it is wrong to suggest that Articles 1 and 4 confer on states a discretionary power. What may be expected from each state in fulfilling its obligation may vary depending on the circumstances, as the Court clarified in Bosnia genocide. But states still have the obligation to act. To say that states have a discretionary power would significantly weaken, if not altogether deny, the obligations to prevent and punish. Ukraine's reference to Djibouti versus France is irrelevant for the purpose of this case. In that case, the Court was dealing with a dispute regarding mutual legal assistance. The treaty in question gave France discretion to refuse requests for assistance based on certain defined criteria. No analogy can be drawn between that treaty and Articles 1 and 4 of the Genocide Convention, which impose clear obligations on the contracting parties. Also in opposite is Ukraine's reference to the work of the Institute on obligations erga omnes in international law. In its 2005 resolution, the Institute was dealing with action that states may take under the law of state responsibility when facing the breach of an erga omnes obligation, such as invoking responsibility and requesting compliance with that obligation. Articles 1 and 4 of the Convention contain primary obligations incumbent upon all contracting parties. They should not be confused with secondary rules. Madam President, it is true that in the circumstances of the immunities and criminal proceedings case, the Court found that the arguments relating to an abuse of rights were something for the merits. But the Court did not say that this must always be the case. It does not have to be the case when a respondent is accused of abusing a right that manifestly does not exist under the treaty invoked. It cannot be the case when the applicant cannot openly and clearly state what that right is, and when the respondent does not claim any right. And it certainly cannot be the case when admitting the existence of the right would create an undefined exception to Article 2, Paragraph 4 of the UN Charter. In short, Articles 1 and 4 impose obligations on states. They do not create rights, and they most certainly do not confer a right to unilaterally use force or to recognize states within the territory of another state. Ukraine's submissions, based on an abuse of rights doctrine, must therefore be dismissed for lack of jurisdiction ratione materiae. Madam President, I now move on to what appears to be Ukraine's last line of argument, having failed to identify a right under the Convention for purposes of applying an abuse of rights doctrine. A more general reliance on the principle of good faith, as reflected in Article 26 of the Vienna Convention on the Law of Treaties. On Tuesday, Counsel for Ukraine stated that a state cannot invoke and execute its obligations under the Convention in a manner contrary to the object and purpose of the Convention. He suggested that since Article 1 does not specify the actions a state may adopt to prevent genocide, it confers a discretionary power on the contracting parties, which must be exercised reasonably and in good faith. And he added that an example of abuse of that discretionary power is falsely claiming a genocide with the objective of claiming a right to act to the detriment of another state, including by using force. Ukraine does not say so expressly, but the suggestion appears to be, in line with Ukraine's general strategy in this case, that if a state does not execute its obligations under Articles 1 and 4 of the Convention in good faith, that the jurisdiction of the Court under Article 9 may extend to alleged breaches of other rules of international law that may be somehow linked to the improper execution of the treaty. This calls for a few remarks. First, as the Court noted in border and transborder armed actions, the principle of good faith is not in itself a source of obligation where none would otherwise exist. In the present context, good faith cannot create additional obligations for states under the Genocide Convention. The principle only relates to the performance of the obligations already contained in the Convention itself. It requires states, following the judgment in the Kapchikovo-Najmarush case, to apply a treaty in a reasonable way and in such manner that its purpose can be realized. Second, good faith cannot be used to expand the Court's jurisdiction under Article 9 of the Convention. As we have reiterated, the Court requires unequivocal evidence of states' discernible, certain intention to submit disputes to the Court. Such an intention could obviously not be established by reference to an abstract general principle of law. Third, as we just showed, Article 1 of the Convention does not confer a discretionary power on states. It is an obligation the states must comply with. It is true that the specific action that a state is required to take is not laid down in Article 1. But one thing is certain. That action is not the unilateral use of force or the recognition of states. These are matters that are exclusively regulated by the UN Charter and customary international law, and which do not fall within the scope of the Convention. This last point is particularly important. The principle of good faith may only apply in proceedings under Article 9 of the Convention to the extent that the obligations under the Convention itself are at issue. If the conduct of a state does not fall within the scope of the Convention, such as the use of force, one cannot use Article 9 to apply the principle of good faith in relation to the conduct not arising under the Convention. Ukraine's reliance on Article 4 of the Convention illustrates this point well. This article only concerns criminal proceedings and the prosecution of perpetrators of genocide. If a state, in the belief that a genocide was being committed, invoked this provision to use force, which Russia denies is the situation in this case, that mere invocation would have no bearing on the legality of such action under Article 4, which does not regulate the use of force. The legality of that conduct will be appraised by reference to the UN Charter and customary international law, but not the Genocide Convention itself, and so would not fall within the compromissory clause of Article 9. The same would be true for an invocation of Article 1 of the Convention for the same purpose. That article has no connection to matters relating to the use of force. So the problem with Ukraine's argument is that it continues to conflate conduct that falls within the scope of the Convention with conduct that falls clearly outside its scope, or, as Ukraine puts it in its memorial, ultra-virus conduct. The use of force and the recognition of states are issues that manifestly do not fall under any provision of the Convention. The legality of the use of force and of recognition cannot be assessed, therefore, within the terms of the Convention. The UN Charter and customary international law regulate those matters, and the principle of good faith cannot affect this. Madam President, members of the Court, to conclude, Ukraine instituted the present proceedings invoking Article 9 of the Genocide Convention. The Convention does not regulate matters relating to the use of force. It does not regulate matters relating to the recognition of states. Article 9, as the Court has already determined, limits jurisdiction to alleged breaches of obligations arising under the Convention itself. The Court must also reject Ukraine's conclusions C and D of the memorial, inasmuch as they require the Court to exercise jurisdiction over alleged breaches of all the rules of international law and order reparation for those alleged breaches. Specifically, the Court's jurisdiction ratione materiae cannot be established in the present case for 5 reasons. 1. Even accepting Ukraine's own alleged facts arguendo, the provisions of the Convention have not been triggered, and the Convention is therefore not applicable in the circumstances of this case. 2. The Court has already established that jurisdiction under Article 9 is limited to alleged breaches of obligations arising under the Convention itself. It does not confer on the Court broader jurisdiction. 3. The Convention itself does not impose an obligation to act within the limits of all of international law when executing or giving effect to the Convention. Such a sweeping incorporation cannot be established as a matter of treaty interpretation, bearing in mind the Court's jurisprudence. 4. The Convention does not confer a right on states to unilaterally use force or to recognize states within the territory of another state. In the manifest absence of these rights, Ukraine cannot rely on an abuse of rights doctrine. And 5. The general principle of good faith may not be used to expand the Court's jurisdiction beyond that conferred by Article 9. Madam President, members of the Court, this concludes my presentation and Russia's presentation for this morning. Thank you for your kind attention.
I thank Mr. Cassato, whose statement brings to an end this morning's session. The Court will meet again this afternoon at 3 p.m. to hear the remainder of the second round of the Russian Federation. At the end of that sitting, the Russian Federation will present its final submissions. The sitting is adjourned.